Mr. Vance, thank you very much for a few minutes. I appreciate it. Certainly the dominant theme of this past year nationally has been police-related shootings,
Right.
especially relating minorities. We saw two very different approaches by two of your colleagues in the 5 boroughs. In Staten Island, the DA, Donovan, laid it out, as we understand it, in front of the grand jury and let them reach their own conclusions when seeing the evidence. In Brooklyn, the district attorney Thompson over there, he made it clear to everyone when questions were raised. He goes, I can go for this. He believed the charge, and he vigorously pursued that charge for an indictment. What do you believe the proper balance is for a district attorney in terms of how hard to pursue for what he or she believes in rather than just putting it to the grand jury and letting them reach their own conclusions?
That's a very complicated question, and there
Glad
is
I
no
asked.
there's no simple answer. So let me do the best I can, and if this is too long, you'll interrupt me. Let me tell you, first of all, what I believe we should do in New York going forward. We sat with the governor, Governor Cuomo, in the aftermath of the grand jury, no true bills in Missouri and in Staten Island, to think and talk about, is there a way to go forward where there can be greater transparency about grand jury decisions not to indict, at the same time that the office of the district attorney doesn't become captured by the desires of some to have special prosecutors replace the work of elected prosecutors who are accountable to the people. Be careful, when you appoint a special prosecutor, you are appointing someone who is not accountable to the voters, the people who elected him there, him or her there. So you want transparency, but at the same time you want accountability. And transparency through a special prosecutor may not necessarily result in accountability to the people.
So if I could interrupt, Judge Lippman's proposal,
Let me get to Judge.
Yeah.
I respect Judge Lippman. I don't think it's the answer.
Okay.
So what we proposed with Governor Cuomo was to have a system where if there was in a fatal police shooting involving an unarmed citizen, to have if the grand jury, after hearing the evidence, voted a no true bill, then the district attorney would be obligated within a specified period of time to file a report. It could be either a grand jury report, which is something you deliver to the grand jury and they vote on, or a written report by the DA, him or herself, excised where appropriate to protect the identity of witnesses. And that report plus materials from the grand jury investigation would be sent to the governor's office, and the governor would have a monitor within his office who would review these materials and then make a determination to the governor and a recommendation to the governor whether or not a special prosecutor should be appointed. Now, I think that's a very sensible way to proceed. I think that the appointment of a special prosecutor requires the governor or someone making that decision to be informed that there was something about the grand jury process that may have been erroneous, error-ridden, not fairly presented, and you don't really get that information from reading the headlines of the New York Daily News or the New York Post. I mean, we're really asking the governor and governors to make decisions about appointing special prosecutors where they have virtually little or no information about what actually happened in the grand jury or is happening. This proposal gives information to the governor to be able to make an intelligent and informed decision about whether or not to appoint a special prosecutor. So I think that is actually a very sound proposal for us going forward. It provides transparency to the public by way of a report, which indicates what happened factually. It provides an opportunity for review by the governor and action if he finds legal errors have occurred, as would be defined in the statute, whatever standard that needs to be met. So, now to your question about the grand jury process. There are two kinds of grand juries, and I think it's important to keep this in mind as you consider and you talk about this issue. There is what I'll call regular grand jury function. Grand juries were created for two purposes, and one of them was to stand as a bulwark between the crown and the citizenry. In America and in New York, that has been moved into a system whereby before we can indict someone for a felony, we had to actually put a live witness or witnesses into the grand jury who are examined by prosecutors in front of the grand jury. The grand jury can ask questions themselves of those witnesses, And the grand jury won't vote an indictment until we have actually put our case, the bare bones at least of our case, into the grand jury. And that's done because the law requires that the grand jury ultimately pass on whether there's probable cause to indict someone or not. So that's the grand jury operating in its bulwark capacity to protect the public from the people. The public actually have to see probable cause that a crime has been committed, and then before that person is charged, vote an affirmative charge. Now, those presentations often tend to be not long ones. Sometimes they are very long, but sometimes they're not. But in any event, even in short presentations, you still have to present the case sufficient for the grand jury to say, yes, I see. There is probable cause that John Smith committed this robbery, and these are the witnesses who've come in and testified. In every case, the defendant is given an opportunity to testify if he or she wishes, or to request to present evidence if he or she wishes. In the overwhelming majority of cases, that's not an advantage that is taken by the defense. The second kind of grand jury is an investigative grand jury. And that's a grand jury which is using its subpoena power and investigative resources in order to understand really what happened. It's a little different than the bulwark grand jury, which is to present enough evidence to move forward with a felony charge. The investigative grand jury is really trying to figure out what happened. In an investigative grand jury, often the responsible thing to do is to get all the evidence out early, to put witnesses into the grand jury early to understand what they saw, what they're going to say, to use the grand jury to bring in reluctant witnesses and to get them on the record about what they saw and what they said and what they're going to say. So in the situation involving fatal shootings of civilians by police officers, it's the practice of this office to put all those cases into a grand jury. It is the practice of this office to use the grand jury in those police-involved fatalities to make sure that we have a full understanding of all the facts that may bear upon the grand jury's ultimate decision of whether or not to charge the police officer. And if that police officer is charged and then proceeds toward trial, that we have a full investigative backdrop against which to prepare the case for trial and control the case at trial. So there's nothing suspicious or wrong or improper about gathering as much evidence as you can in an investigative grand jury, because that's really when you want to get the evidence. When you want to get the evidence when it's freshest in people's minds, and from all the precipient witnesses who have something to say that bears upon what happened. So the final thing I'd say is that New York State actually has one of the most robust citizen-involved circumstances of criminal investigations among the states. And I've practiced in many states and in many federal courts. Many states don't use the grand jury process at all. The prosecutor, he or she alone, calls witnesses into her office or otherwise interviews witnesses and makes a judgment call without really any record made at all about what informed that decision to proceed or not to proceed. And in many states, that also applies to police-involved shootings. DAs will make decisions based upon an investigation, but not one based upon sworn testimony and witnesses testifying before the grand jury. So we in New York take a more, I think, more expansive, more open posture in terms of both requiring us to put witnesses into a grand jury before we vote a charge, as well as the desire to create a full record of what happened. Then you have the federal system. The federal system operates where one could admit an enormous amount of hearsay in the grand jury. So an FBI agent in the federal system can come in and essentially put in an entire case through his testimony based upon his reading of investigative memos he's done of other witnesses. Now let's take the state system. We are obligated to put live witnesses in. We can't do it through hearsay for the most part. So we actually have one of the most, I'd say, active record-making investigative processes that exist in the United States. And so when people call for changing the grand jury process, I think we've got to understand what's better out there, Do we really want a system where prosecutors make the judgment, him or herself? Do we want a system like the feds where hearsay is admissible as substantive evidence in the grand jury, and grand jurors are voting indictments based not upon live testimony oftentimes, but upon hearsay read by an agent? Or is the New York State system so bad where we actually have to put a lot of evidence into the grand jury? All that said, I support the proposal that we came up with Governor Cuomo, and I think it bears real review by the legislators, and I think should be viewed as a real step forward by the citizens.
But you know the open debate that happened post-Ferguson and post-Staten Island specifically, which was that old expression, you can indict a ham sandwich. Fair or not, the perspective's out there that if the district attorney in his or her respective office wants to secure an indictment, they can handle it differently than if they don't. And there's been criticisms that some DAs were looking to basically pass the buck to somebody else because they didn't want it. There is philosophies. Every former prosecutor that's talked to me said that their office, whether it's in the suburbs, the cities, or even on the island, have said, our office did it this way. Is there a clear line that your ADAs know that if there is a high-profile case, your office, if you're going to charge somebody, you're going to pursue it to the fullest, or you're going to give it to the grand jury to make their own determination without being led one way or the other?
Again, I can say that I've not experienced when I was a district attorney, assistant DA here in the 1980s, nor do I experience it overseeing the indictments that we now file, that DAs are doing anything other than what their job is, which is to fairly present evidence to the grand jury and to charge the grand jury on the applicable law. And then ultimately it's the grand jury's determination of whether or not to vote an indictment. There's no summation in the grand jury by the DA. There's no opening statements other than to just frame what the case is going to be about. And there was a grand jury presentation earlier this week where we were presenting felony charges to the grand jury, but the grand jury voted a misdemeanor. I mean, grand jurors exercise more responsibility and control than the public understands or your question implies. And so DAs don't, certainly as a matter of practice, in my view, slough off responsibility to a grand jury in order to achieve a preordained result.